Good morning. You are Catherine Castillo, and Ms. Castillo has two cases. She's assault of a peace officer and then also driving while intoxicated, third or more. And what is the announcement?
Your Honor, we need 30 days. I've received all the discovery. We're going to review the video evidence. I have an offer now. I'm going to relay that to her. We'll meet before we come back, and the case will be disposed of on that day.
Okay, this will be the last for an announcement.
Absolutely.
Ms. Castillo, make sure you get with Mr. Pageant. Now that he has everything, you guys can go over all that discovery, see what your options are, and we'll take care of your case at the next court date.
Yes, ma'am.
Okay, you're free to go. Thank you.
Thank you, Your
Mr.
Honor.
Pageant.
May I be excused?
Yes, sir.
Thank you. Thanks for that.
Good morning, sir. You're John Martin.
Yes, ma'am.
And Mr. Martin is charged in cause number 25 DCCR 0583 with injury to a child, elderly, or disabled individual. And Mr. Burbank, what is the announcement?
I believe the state and I are looking for some CPS records. Is that right?
I don't see that there's been an order for those yet.
There hasn't, Judge. I'll get one filed. I won't need to talk to Mr. Burbank to see if he already has one. He does not, so I'll be sure.
Okay, yeah, let's get that done quick because it takes a while, it seems like, on some of those. I'll sign that order as soon as it comes through. Let's go ahead and just do a 60-day reset because obviously it'll take a little time once I sign that for those to come in, but hopefully they'll come
They
in.
may have them over on the civil side, upstairs.
Okay, all right, yeah, if we can get
I'll
on
check
that way,
there, Judge,
that'd be
and if
great.
not, I'll reach out to Miss Adams. She
Okay.
usually gets them to me
She
pretty
is.
quick.
Thank you. All right, Mr. Martin, stay in touch with Mr. Burbank. He'll let you know when you need to be back. You're free to go, sir. Yes, thank you.
Thank you.
Ms. Holmes, you have TJ Landry. Good morning. How are you?
I'm going to have the email about the attachment.
Okay. Good morning, sir. Are you TJ Landry?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Landry, in cause number 24, DCCR 0165, you're charged with the state jail felony offense of theft from a person from December 9th of 2023. And how do you plead to that charge?
Yeah, show me no contact.
You either did it or you didn't do it. Are you guilty or not guilty?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak out loud, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
It looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And is there any restitution?
No, the shoes were recovered that
Okay.
day.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Landry is not
No,
competent?
Your Honor.
And Ms. Malfino, with regard to waiving pre-sentence report, is there any issues with regard to history I need to?
No, Your Honor, it looks like there may be some misdemeanor contact, but he has no felony history. I have no.
All right, so what I'm going to do, Mr. Landry, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right, I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. In just a few minutes, probation's going to call you up to go over your paperwork. She's sitting at that desk right there, so watch for her to call your name, okay? Good luck to you, sir. Yes.
Sorry to interrupt.
Hang on.
Just, since we're waiving the PSI, may I ask to request of the court that one, he be trespassed home from Parkdale Mall, and that he not be allowed to have any contact with a Jalen Nixon or Reginald Guillory.
All right, so I'm going to order as a condition of your probation, Mr. Landry, that you are not allowed to go on the premises of Parkdale Mall. That'll be a part of your probation. Also, you're to have no contact or communication with Jalen Nixon and tell me the other name?
Reginald Guillory.
Reginald Guillory. So that means in person, y'all can't hang out, but it also means any other way. You can't send messages, you can't Snapchat or DM or anything like that. You go live your life, and whatever they do, they need to live theirs. Make sense?
Yes, ma'am.
All right, you can have a seat. Thank you, Ms. Malfino. And then, Ms. Holmes, you have Edmund Latulas? Edmund A. I'm sorry, I do that every time. Oh, I don't see her, so,
We didn't record.
okay, I'll recall her as soon as she's ready.
Actually, she can take some.
Mr. Lewis, are you still working on Deshauna Bass?
I'm sorry.
Oh, okay, hold on, let me, y'all can come on up. Okay, we're going on a lesser. And this is Mr. Coleman's on Deshauna Bass. Good morning, you're Deshauna Bass? And will she waive the formal reading of the indictment?
She does, yes.
And Ms. Bass, in cause number 24 DCCR 2316, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from October 27th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
This opening might sound routine, but notice how quickly the judge sets the tone to serious charges right out the gate: assault on a peace officer and DWI third, or more. That's not just a traffic issue, that's felony territory. Watch how calmly the courtroom handles what could have been a volatile case.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bass is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for a period of 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up in a few minutes when she's ready to go over your paperwork. So she's at that desk right there, so be watching for her to call you up, okay? Good luck to you, ma'am. Thank you.
Thanks, Judge.
Thank you.
And your signature's not on that.
Yes, ma'am.
Yes, ma'am. It's like it doesn't matter if it's long or short. It's always the same. Mr. Rennick was just here.
Mr. Crenshaw went back there.
He's his client, Judge.
That's why I didn't. She's not asking. I'm just trying to figure out one details.
Let's see, Ms. Holmes on Edmund A. Latulis, I'm ready on that. Good morning, ma'am. You're Edmund A. Latulis. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Latulis, in cause number 24, DCCR 2057, you're charged with the state jail felony offense of abandoning or endangering a child, and that is from June 14th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them? Speak up, please.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $300 fine. You would be required to follow all of the rules and conditions of probation, including any referrals for any type of emotional support or counseling that you need. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation? Mr. Frazier, can you hold it down, please? That your plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Latulis is not
No,
competent?
Your Honor.
And
Judge,
do we need to get a PSI just so we know what all needs to? I think so too. All right, ma'am. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing. Thank you. Mr. Rennick, you have a sentencing on Ryan January?
Yes, Your Honor. Good morning.
Good morning, how are you? Yeah.
Back in Vegas last night.
Oh, nice. It's hard to feel sorry for you.
McCartney.
Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing.
Negative.
Negative. All right, sir, you're Ryan Eric January.
Here's a key moment when you hear injury to a child, elderly, or disabled individual. That's one of Texas's most serious offenses. But instead of moving fast, both sides pause for, you guessed it, CPS records. Those Child Protective Services files can make or break how harshly this case is treated.
Speak up, please. And Mr. January, in cause number 25, DCCR 0370, was previously in court, entered a plea of guilty to the third-degree felony the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have
Any additions or corrections?
nothing but
So I guess I had a question. I did not realize if we do this on all or if this, but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or,
We have.
I'm sorry.
I can look into it for you, Judge.
Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life. And so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you talk to probation. They'll let you know how to get started on that. And you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a probation conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir. Numbered it. This, Donald Owens, where is it?
It's on the trial docket, Judge. It's on Kelly.
Oh, that's today's. I'm sorry. That's why. Mr. Kelly?
Yes,
Donald Owens?
he's present.
Good morning. Good morning, sir. You're Donald Owens Jr. And Mr. Kelly, will your client waive the formal reading of the indictment?
We do.
Sorry, it's going a little slow. It's stopped spinning now. Oh, there, shut up. All right. Mr. Owens, in cause number 24, DCCR 1192, you're charged with the second-degree felony offense of sexual assault of a child from March 29th of 2024. And how do you plead to that charge?
See what the judge just did there? That's called an immigration advisement. Anytime someone pleads guilty, the court must warn non-citizens that it could lead to deportation. Even if they never mentioned immigration in the case, it's standard. Pretty wild how much legal fine print rides on a single guilty.
Are you pleading guilty freely and voluntarily? And because they you did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? And do you fully understand them? And my understanding is there is no plea bargain. This is just open to the court. Is that correct?
That's correct.
And that there is, in addition, not a waiver of the right to appeal because of that as well, correct?
That's correct. Correct.
And is that your understanding? That I want to make sure you understand, Mr. Owens. Obviously, you know your case is set for trial to begin with jury selection this afternoon. You have every right to have that jury determine if you're guilty and what your punishment is. If we go forward this way, you're pleading guilty and you're leaving your punishment up to me. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
Objection states one.
It's admitted. Is there any evidence that Mr. Owens is not competent?
There's not.
In addition to that, Mr. Owens, you do understand that as a condition of your plea in this case, that you will be required to register as a sex offender. And I have that document that you've signed with Mr. Kelly, and y'all went over that this morning, and you understand it. All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So for sentencing, since it's unagreed, do you guys anticipate lengthy hearings, witnesses? What type of time frame do we
Expect
need?
us to call witnesses, Your Honor.
Okay, any more than an hour's worth? Something we could do at the end of a docket? Or do y'all anticipate more
I
than
don't
that?
anticipate any more than that, Judge. We may have one witness,
Okay,
but I don't want to confine us to that. If it goes over, I only expect.
no, I mean, I want that, well, that's what I want to
Yes.
figure out, is if you anticipate that it could be longer than that, then I can set it on a date other than a Monday, when we don't have a trial or something like that. But if you
Yeah.
think y'all can get it in at the end of a docket from 11 to 12 or,
If the court can consider not putting it on a Monday, that's what we would ask for.
okay, all right, we'll take a look at appropriate date for that and let y'all know that court date. Obviously, anything you think is important for me to know, get that information to Mr. Kelly, and then I will look at all of that and listen to everything when we come back. All right, don't forget to stop and talk to probation. Thank you.
Your Honor.
Thank you, Judge.
How the judge just went full modern-day parent mode. It's not often you hear no DMs in a courtroom order, but this is real. Violating a no-contact clause online counts the same as doing it in person. Quick question: should judges adapt to social media slang like this, or keep it strictly formal? Drop your take below.
Mr. Crenshaw, you have Timoteo Castaneda.
Yes, Your Honor.
Good morning.
Good morning. Good to see you.
You too.
Sorry
That's all right.
about the kids.
Good morning, sir. You're Timoteo Castaneda?
Yes, Mom.
And in 25 DCCR 0360, Mr. Castaneda is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, if we could come back, we're very close. We're trying to get a probation offer, and once we get that, this will be resolved. We're just not quite there just yet. I think we've only been here once.
Well, it looks like you were hired in May, so this will be the last reset on this
Okay,
case. So, Mr. Castaneda, make sure you stay in touch with Mr. Crenshaw so that any information he gets from Mr. Hoffpower, you guys can go over and we'll get an announcement at that next court date. All right, thank you. Catherine Jordan, Mr. Crenshaw.
Yes, Your Honor. This is going to be a plea. We need Mr. Coleman. I believe he's here today.
Okay,
If we could just come back on a standard reset. She was trying to get the full restitution, and the good news is she has that. And
so I can set it on an actual plea docket and y'all will get it taken care of
Yes.
on a plea docket?
yes.
Okay, then I will reset it to a plea docket. Obviously, once it's on that plea docket, I expect it to enter a plea on that day. If anything changes before then, just let me know.
We sure will.
Stay in touch with Mr. Crenshaw. He'll let you know when you need to be back, and we'll take care of that. All right, thank you. Good morning, sir. You're David Melanson? And this is 24 DCCR 1186. Mr. Melanson is charged with assault on a family member with previous convictions. And is there an announcement? It looks like you were just hired on this one.
I was, Judge. We're actually on the next setting, I think, going to, the state's going to subpoena the complaining witness.
Okay.
And I think we'll have a resolution on that date.
And
Okay,
I have not heard from her since June of 2024, Judge, but if the court would allow
Sure.
me maybe 30 days to send a subpoena.
Yeah.
And Mr. Crenshaw has also presented me with information that he believes there's a non-prosecution affidavit, so we're both going to try to get our hands on that.
okay. So I'll just do a normal reset to give y'all time to get that taken care of. Make sure you stay in touch with Mr. Crenshaw. He'll let you know when you need to be back. All right, thank you.
This part always hits deferred probation isn't just mercy, it's a second chance with strings attached. Think of it like the court saying we'll trust you once one mistake, and that kindness flips into a full conviction. Do you think that's fair or too risky? Now, this is interesting. The judge turns a punishment into a push for personal growth. Requiring a GED isn't about control. It's about giving defendants a way out of the cycle that brings them back. Here, not every courtroom ends with a redemption note like that.